Perfect. So good evening, everyone. My name is Patricia Taylor. I am a Commercial Litigation Associate with DLA Piper and the Vice President of the Scottish Young Lawyers Association. I'm pleased to be chairing tonight's event alongside my SYLA colleague, Chiara Pieri. Chiara is a Contentious Construction Associate at Shepherd and Wedderburn and the past President of the SYLA. Thank you so much for joining us for the next instalment in our widely attended So You Want to Be series, where tonight we will be lending our focus to becoming solicitor advocates. We're joined by an expert panel of speakers who will explore their respective journeys to becoming SOLADs, the course requirements, their motivations behind completing the course, and the benefits of obtaining higher rights of audience.
So we're pleased to welcome Lauren Ray, who is a partner in the commercial litigation team at DWF, Ian Drummond, who's a partner of the construction, engineering and infrastructure disputes team at Shepherd and Wedderburn, and David Ford, who is an associate at Brodie's who specialises in real estate litigation. So our panellists are all solicitor advocates, and before we begin, may I just encourage everyone to ask as many questions as you like using the chat function. Patricia and I have some questions for the panel, but please don't be shy. Just feel free to pop any questions in as and when they come to you, and we'll come to all questions later on. Also, for people that are just still trickling in, if you could just keep your cameras off and keep yourself muted. And I think the best way to view these sessions are as the speaker view, and that will allow you just to see those people that are speaking at any one time. So if I could just come to each of our speakers and ask them to tell us a little bit about themselves, how long they've been in practice and when they decided to become solicitor advocates. I'll come to Lauren first.
Thanks, Chiara. Evening, everybody. Thanks very much for all coming along to hear us speak about our journeys to becoming solicitor advocates. My name's Lauren Ray, and I am the partner and head of commercial litigation at DWF. I'm still getting used to saying that because I only joined DWF in August and I spent 13 years at Thornton's. So I do still accidentally pick up the phone and say that I'm formally from Thornton's. But I've specialised in commercial litigation for 13 years, and I did my solicitor advocate training in January 2019.
Thank you, Lauren. And I'll just come on to David and ask the same question.
Thanks, Chiara. Good evening, everybody. So as was said in the introduction, I'm an associate at Brodie's. I specialise in real estate litigation, having trained entirely in litigation, including a 6-month secondment to the Scottish Government. I qualified as solicitor in July 2018, and very much the baby solicitor advocate of the group. I got my higher rights of audience in July of last year.
Thanks, David. And Ian, if I could come to you next.
Sure, thanks, Chiara. So I work with Chiara at Shepherd and Wedderburn. I'm a partner in our construction disputes team, as Chiara said. I hesitate to describe myself. David described himself as the baby of the group. I'm not quite sure what that makes me. But similar to the other two panelists, I trained as a litigation lawyer. So I qualified in 1995. And I trained initially as a sort of general litigation lawyer. Then I specialized first in contentious planning and also contentious construction, so both. And then I moved towards specializing in contentious construction. And I did the solicitor advocate qualification in 2004, and I think I got my qualification in 2005. So it was a while ago. So I guess I was about 8-9 years qualified at the time.
Great, thank you. And I guess probably quite an important question is what were each of your motivations for completing the solicitor advocate course? You know, for example, was that based on a decision of your firm, or was it a business need, or did you just really love being on your feet? Lauren, I'll come back to you.
Thanks, Chiara. I think it was a bit of both for me. So I did, of my 2-year traineeship, I did 18 months in litigation, and I always kind of knew that that was where I wanted to be, and it was something I couldn't tell you why, but I always, even from school, I knew I wanted to be a solicitor, and I did an S3 solo talk all about becoming a solicitor. So I don't come from a family of lawyers by any means, but it was just something that always appealed to me. And when I qualified into the commercial litigation team in Thorntons, I was quite clear that I wanted at some point in my career to become a solicitor advocate. And I spoke to the partner who I was working for at the time, and that was something that he was really supportive of. And indeed, there was a business case there as well, because there wasn't a commercial litigation solicitor advocate within the firm at that particular time. And so I guess the answer to your question is it was driven by my own desire to obtain higher rights of audience, but also because there was a business case. And that, I think, because I'd formed those views quite early in my career, meant that, and because my firm was on board with that, that meant that it worked quite well, because I did the vast majority of the team's proofs and debates and appeals and things like that. So because I had that desire, the team were brilliant at diverting that work to me, so that I could ultimately make sure that I had sufficient experience when once I had my 5 years PQE, and I was able to then go and become a solicitor advocate.
Great, thanks. And David, what about you?
A lot in common with Lauren, actually. Certainly, I'd always had an interest in advocacy and become heavily involved in mooting when I was at university. And I probably had certainly at least one eye on the Faculty of Advocates as a potential career destination. But about halfway through my traineeship, one of my colleagues took me aside and just said, look, there's a really good opportunity for a specialist real estate litigation solicitor advocate at Brodie's. Is that something that you'd be interested in pursuing? Would you be on board with making that your goal for the early stages of your career? And certainly, I really, really liked the people that I was working with, and also the work that I was getting to do, and I could really see the opportunity for growth. So weighing up those opportunities, I decided that was the path I wanted to go down. And having had that conversation, similar to Lauren, I was then lucky in that to progress and develop with the firm, focusing on that meant that I was being passed the necessary work to build up the skills and the experience that you need to get onto the course in order to obtain the qualification. So if I had to sum up sort of why I've ended up here, it's probably absolutely a desire to be on my feet and arguing cases and pleading cases, coupled with just an environment that encouraged me and that I want to be in to do that.
Thanks, David. I think that's really helpful to know that you've had the support, of your respective firms. And Ian, could I come on to you? What was your motivation for doing the solicitor advocacy?
Well, I mean, I was probably slightly later in developing that as something I wanted to do than perhaps Lauren and David have just said. So just to go back a bit further, I mean, I wasn't sure that I wanted to be a lawyer at all up until the point I started university. And then I wasn't sure I wanted to be a lawyer at all for my entire degree at university. But probably like a lot of people, I thought, having done all that hard work, and I did enjoy lots of elements of it, I went on to do my traineeship. And I found that really I didn't enjoy the seats up until my last seat when I did litigation, which fortunately I did really enjoy, because I was beginning to despair a bit as to whether all these years of training would be had been a bit of a waste. But I really enjoyed the last seat. And so that's when I qualified and became a commercial litigation lawyer. And I mean, I really enjoyed the aspect of pleadings and appearing in the Sheriff Court. To begin with, I really enjoyed that. I find myself really interested in reading Sheriff McPhail's book on Sheriff Court practice and reading the notes to the Court of Session rules, to give me tips as to how to present and argue and so on. I was just fascinated by all of that, and I got a lot out of it. And I did a lot of Sheriff Court appearances right from early on. And I think a bit like Lauren said, because there was a general awareness that I really enjoyed doing them, and I, as it happened, I was quite good at them. Other people started giving me their appearances, so I found that I was all around the country in the sheriff courts doing debates and lots of hearings and so on. And I found it was something I was quite good at, and I enjoyed doing it. And then as I got on a bit in my career, and I started specializing a bit more in construction work, I got into arbitrations at that time. It was a bit before the time of adjudication, but I got into arbitrations. I started doing hearings in arbitrations. And I remember doing a debate against David Williamson of Brodie's, who was the first ever solicitor advocate in Scotland. And, I did pretty well. I think I won the arguments, but most of all, I really enjoyed it. And, I sat down with David Williamson afterwards, and we had a chat about it and his career as solicitor advocate. So, I found I was good, and I was competing against counsel in hearings and getting on pretty well. So I just really enjoyed it. And then I think one thing particularly that was a trigger point that I always remember was we had this case, and it was simply it was an additional fee motion, as was called in those days, in the Court of Session, where we had somebody instructed for us. And I remember standing just before going into court. There were no clients around, it was just solicitors, and we were standing there, and the representative that we'd instructed, I said to this person, so how do you think it's going to go? And I remember that person saying, well, all I can do is present the arguments to the judge and see what happens. And I thought, I can do better than that, because it's the advocate's job to persuade the judge. You don't just put the arguments to the judge. That's the whole point. Anyone can do that. The whole point of being a skilled advocate is you try and persuade the judge that your argument's better than the other one. So that was a real trigger point for me. And then I think around about that time, I was getting senior, and I was actually made a partner about 2005, and a bit similar to David was describing. I mean, nobody came to me and said, how would you think about being a solicitor advocate? But that was the way I was going, and there weren't any others in Sheffield and Wedderburn at the time. So I thought, well, I'm a new partner. I need to make my own way in the world as a new partner. Actually, that's a good additional sort of, business element to have. And so at that, from that time, I started doing hearings in the Court of Session on other people's cases, and it just became an extra element of my business. And obviously it brings in additional income. So it was something that I really enjoyed. So that was it.
Thanks, Ian. So David, you most recently completed the course. So I was wondering whether you could maybe give an overview of the kind of pre-course requirements and the application process.
Yes, no problem at all. So before you can even make your application to the Law Society to be admitted onto the course, the first thing you have to do is go along to what's known as the introductory course. It's a mandatory course. It usually has to be done within 2 years of the date you actually submit the formal application to the Law Society. And it's a joint course that's attended by both the candidates for the criminal course or for the civil rights of audience course. It'll last half a day, and on the course you'll hear talks from members of the judiciary. So I think it's Lord Eric and Lord Armstrong that do the 2 talks at the moment, as well as from those involved in running the course at the Law Society, and from experienced solicitor advocates who have obviously done it before themselves. And really that's just to give you an idea of what's going to be involved in the course, how does the application process work, and what's going to be expected of you as a candidate for your higher rights of audience in either the Court of Session or the High Court or Justiciary. And as I say, it's only run once a year. It's typically in January or February, so one just took place a few weeks ago. And I'd simply say, because it's only once a year, if you are interested in obtaining rights of audience, I would encourage you to try and get a place on that, just so that opens up the application, the opportunity later in the year to make your application. You then roll forward typically to sort of late summer, autumn time, and that's when the application goes live on the Law Society's website, and you have to fill out a form. In that form, you have to set out a brief CV, your experience in the Sheriff Court, your experience in the court of session, instructing counsel or being involved in cases there, and in any other relevant tribunals or other similar court type bodies. And I'd make that point that if there's anyone on this call who's maybe not got particularly heavy court practice but is in a tribunal all the time, don't worry about that. The form's designed to take that into account to make sure you get the credit for it. And finally, you get to add anything you've contributed to or attended that has an advocacy focus. So if you've been going to talks or lectures or seminars or any CPD events that have an advocacy focus, you get to include those well on the form. And then the final bit is your two referees. So one of your referees has to be a sheriff that you've appeared in front of. And the second referee has to be someone who has experience of your written pleadings. Most cases, it probably is two sheriffs that do that, but I'd simply reiterate the point I made earlier, that if for whatever reason your practice doesn't bring you in front of sheriffs because you're in front of tribunal judges all the time, don't think that's a bar necessarily to being able to apply. Just speak to the Law Society about that. Once you've done that, you send your application off to the Law Society by the deadline, which I think in my case was the end of October. And then normally about a week later, the Rights of Audience Committee meets. They go through all the applications and confirm whether or not they're satisfied that you've got the necessary experience to justify being admitted onto the course. One of the key points about the course is it's not like deviling, where if you go off to the Faculty of Advocates and start deviling, they very much take you as fresh-faced and new and build you up from the ground the whole way through. On the extended rights of audience course, it's expected and required that you've already built up some experience appearing in the courts and having some knowledge of the relevant rules and procedures. So the application really is all about just being able to demonstrate that.
Having to write off to two sheriffs as referees sounds quite nerve-wracking, to be honest, David. Did you have someone in mind already, or how?
I would. It's far less nerve-wracking than you think. I was the exact same sort of slight tease about how on earth I was going to find two sheriffs to, one, know who I was, and two, agree to say something remotely nice about me to the Law Society. My top tip on that would be, if you get a decision in a case that you've appeared in, it may be a debate, it may be a proof, it may just be a very chunky motion. As soon as you get the decision, if you've got the course in mind, write to the clerk saying, would you mind asking Sheriff X if they'd be willing to be a reference in due course when I apply for the Rights of Audience Committee, to the Rights of Audience Committee, because you're fresh in their mind, they've just written about you. If the decision's gone your way, perfect. If not, they'll still no doubt have appreciated the quality of your submissions. It's just on that unfortunate occasion where the law or the facts are occasionally against you, and that's a really easy way to do it, because you're kind of trading on that rapport you've built up in the course of the hearing. Whereas sometimes, I did a really good case 2 years ago, I'd love to use that, and you then write to the sheriff and he's sat on a 200 cases since. It's a bit more difficult to perhaps get in there. So that would be my top tip on the Shrivo references.
I'm sure many will thank you for that. No, it definitely is a good tip to have it in your mind from, whenever you're doing appearance work, because that was my first thought. How is a sheriff going to remember who you are? So thank you, David. Lauren, could I just come to you to describe the course itself, or like the structure of the programme, what's covered, and any tips for making the most of it?
Absolutely. David, you can correct me if there's anything that's changed since I did it. So by all means, please jump in. But when I was doing the course back in 2019, it comprised of 3 weekends. It was two of them were taught, so there was various speakers over the course of the weekend, and then the third weekend was for your oral assessment, and you only went in for your given slot. But I went back in preparation for this. I went back through my trusty kind of notebook that I still have from my solicitor advocate training, just to refresh my memory about the format. And I think it would be fair to say that people from, or the members of the justiciary, and also the faculty of advocates that give up their time, you know, and indeed other solicitor advocates to come and, you know, and teach on the course, you know, and the quality of those people, you know, are worth kind of mentioning. So I went back through just some of my my notes to see who was kind of teaching me, but it was as I say, it was the 2 full talk weekends, Saturday, Sunday, you went through from about 9 till 4. So I had Lord Docherty, who did an update on the commercial court practice, and Lord Brodie then gave a talk on just some tips on appearing in the inner house. Michael Upton at the time was doing a seminar on grounds of appeal, and when I was doing the course, one of the assessments is to draft as homework grounds of appeal, and so that's a really important kind of session, getting all the kind of tips, and you then take it away. And I think Michael was the one to mark that piece of homework. I also had Stuart Gale KC, who did a talk on judicial review, and then there was various workshops from Tim Edwards on pleadings, Simon Bowie KC on a pleader's guide to evidence. Lord Hodge did a talk on appeals to the Supreme Court, and Kenneth Campbell KC did a session on witnesses, just to cross-examination, examination in chief. So it's a really, you know, high caliber of you know, people that are giving up their time, you know, to help kind of teach you. At that time, Craig Connell KC was the convener, so also kind of benefiting from all Craig's experience as well. On the second of the talk weekends, you have to do a mock oral assessment, and I think everybody, you know, there's that intake of breath, because it's, of course, it's taped and then it's played back to the room, you know, and at that point you see, you know, that you're fiddling with your hair, or you're fiddling with your ring, or, you know, whatever. But it really is, you know, it really is invaluable, just to, you know, to watch yourself back and just try and kind of pick up tips. But I, for my part, I would say I absolutely loved the course, and I just tried to take it all in, and I hope what I'm kind of playing back is just my enthusiasm for it. And so, as I say, in terms of what I, you know, some tips from me, I still use my notebook. You know, I still have my notebook. The volume of materials you're provided with in terms of styles, you know, even kind of years later, I still go back to that and use it again. So I think it's just about, you know, being keen, immersing yourself. But I think the thing to remember about the Solicitor Advocate course as well is that it's not really a taught course. And when I looked back on my notes, I now remember Craig Connell saying that it's a study course. So the fact that you have these people coming along and, you know, trying to you know, give you kind of information, it is actually very much designed for self-study. So you know, you do then go away and you do study, and you do look at the rules, and you do look at the you know, the points of kind of practice and things like that. It's not something that you're just meant to kind of regurgitate. You are meant to kind of learn it for yourself. And I think that comes back to what David was saying, that it's not the deviling and breaking you right down and building you back up again. It's about that you should you already have a kind of level of experience. You should then be able to go away and you know, and study and you know, become more acquainted with the court of session rules and procedures.
Thanks, Lauren. That's really helpful. And so that's kind of about the programme itself, and you touched on the exams slightly. Ian, could I come to you to ask you about the examination process, and again, just any sort of tips that you've got for anyone listening?
Sure. I mean, I am sure it's changed a fair bit since I did it, so I defer to Lauren and David on how it's actually done now. But when I did it, I guess it was in 3 parts. So you had the written part, which took place at a sort of neutral external venue, and as far as I remember, it was a mix of I don't think there were any multiple choice questions, but it was a mix of sort of written questions about court procedure and that sort of thing. And then you had to do some drafting as well. And as far as I remember, there was an element of open book to it. I can't remember if the whole thing was open book, but and there was an element of open book to it, and I think it lasted a relatively long time, but not all day, as far as I remember. And then, as Lauren said, there was the oral element to it as well, the oral presentation element, which was on a different day. And then the third element to it was the sort of homework piece that Lauren was talking about, which was like an assessment of a draft appeal case, a note of argument, which I had to do. And then not only part of the examination, but we had to do, excuse me, some sitting in days as well, which was observing a debate or proof for a certain number of days in court. And I think it was, as far as I remember, it was 6 days when I did it. And I remember really enjoying all of that. So, I mean, I'll hand over to David and Lauren to correct me on any elements of that just in a minute. But in terms of my experience of that process and practical tips, I mean, I've always done well enough in exams. I've always got what I needed to get, but I've never been a natural at exams by any means. And I certainly don't remember ever particularly enjoying them. But I do remember enjoying these exams. And I think they're not sort of exams as you remember them at university. It doesn't feel like a test as such, because you know that the people who are running the course, they want you to pass. They're trying to support you and help you to pass. And at the end of the day, you've got to pass. You're not aiming for, as you like to think at university, you're aiming for 75, 80% or whatever it is if you're ambitious in terms of the results. You're aiming to pass, but it's also in something that you want to further your career to do. So it's obviously something that you're very interested in. And I found, like Lauren said, preparing for the exams just very interesting. And then when I went to do the exam, the written exam, I just felt like it was almost being at the office and dealing with a client problem, and a piece of drafting that I had to do in relation to that client problem. So it just didn't feel the same way as exams that I'd been used to doing before. And I think, I mean, practical tips, I remember just looking at a lot of styles, refreshing my memory on the court rules. And, I guess I would have read McPhail again and other court procedure books. But I mean, I don't remember doing hours and hours of study. I remember, doing a fair amount, but it didn't seem to be as much as I remembered having to do at university. So I just found the whole process, not intimidating as I used to find exams. I just found it enjoyable. And I even remember the oral exam, being quite surprised how unintimidated I was, because we had to go and do it. I think we were split into groups, and you had to do the oral presentation in a group. So essentially you were doing it in front of your peers, which can be nerve-wracking. But again, I remember being surprised that I didn't find it as nerve-wracking as I expected. And I guess looking back on it now, I'd put that down to just because it's something that you really want to do. Whereas at university, the subjects you're being examined on, where you're not particularly interested in the content. So it's more of a sort of job to apply yourself to learn. But in this case, I just found it was very interesting.
Thanks, Ian. I'll come back to David then, just to chip in with anything about how the exam is now, and I don't know whether it has changed at all. Maybe you could tell us.
Yeah, no, it's changed slightly, but in terms of content, it's very much the same. So it may just help if I talk you briefly through the exams and assignments I had to do on top of the weekends that Lauren's already mentioned. So we still have the grounds of appeal take-home assignment. That's the first assessment you do. It conveniently follows shortly after a very helpful, very detailed day with Michael Upton, Advocate, having him train you up on what's expected and what you need to do. And that's, I think, you get 4 or 5 days to complete that. So it's relatively easy to fit around. It's just a case of be aware it's coming and make sure you set a bit of time aside to deal with that. You then have your written pleadings exam. It's in the diary for a scary 6 hours and 45 minutes. You don't need the 6 hours and 45 minutes. It's designed that you get it at 9 o'clock. It's due by 3:45. you have a day, make sure you take a break for lunch, because you have to draft a summons, a set of defences, and a petition for judicial review. Please don't panic about the petition for judicial review. I'd never done one in my life. I'd done very little JR work, if any at all. You, with rights to appear in the Sheriff Court, you get no experience of running your own JRs. It's always something that goes to council, but you get trained up very well on it. And there's a whole, I think one of the entire days at the weekend is devoted to JR procedure. So you've got your written pleadings exam. You have your oral advocacy exam. We were very lucky. In years gone by, it used to be done in the Law Society's offices, but I think as a treat for us, because the course had been online and the courts were starting to open back up, we got to go and argue our reclaiming motions. What you have to do is you get sent papers and you have to prepare submissions that you would make to an inner house division. And we had to go along to Court 1 in Parliament House and argue them in front of Lady Haldane and Lord Braid. So that was quite the experience. I think, as Ian said, sounds a bit daunting. It's absolutely terrifying until you get about a minute into it, and then I think you relax into it and you just enjoy it, because it really is a great experience. And then your final 2 written exams. I should have said the written pleadings is open book, so don't worry, you get all your styles in. Your final 2 exams at the end of all this are professional conduct. That is a closed book. That's just about your everyday practice plus an extra couple of rules that apply to those with extended rights of audience. So you just need to read the rules, memorize those. They're not difficult. A lot of it's common sense and just good practice. And then your final exam, which Ian's referred to as the practice and procedure. So that's kind of anything's fair game across any court procedure that you might have in the court session. But again, you're allowed to go in armed with all the books you might need. And there's probably 6 or 7 core books. For example, court session practice, annotated rules of the court session, McPhail, McSporran on commission and diligence, Hennessy's civil court practice. You go in with them. By and large, you're going to cover all bases. So that's the sort of current exam structure.
Thanks, David. That's helpful. And before I pass on to Patricia to ask some other questions, I'm going to be cheeky and ask, how hard are the exams?
I'm happy to chip in with my recent flashbacks to them, so to speak. But no, I joke. It's like anything. If you take the time to do the preparation that you need to, you're going to be absolutely fine. For me, the most important thing and probably the most time-consuming thing is getting your materials in a sensible order. So for your pleadings exam, know where your style summons for a prof neg action is. Know where your JR to challenge a planning permission is. Because as long as you go in with the materials organised in a sensible way, then in the open book exams, you're going to be able to come up with an answer to the question. But that isn't something you can prepare the night before. It's something I'd be thinking about throughout the course. And also practice. It's been a few years since I'd done any exams. So it was a bit of a shock, and just getting up to speed again with writing at pace under stressful. So time yourself and have a practice. You can ask for all the practice papers before you do it, and all the past papers. So that's definitely worthwhile doing. Focus on what you're not comfortable with. I've done very little JR. I've done very little PI. Both are likely to come up in some way or form in the exams, so know your weak areas and don't put them to the bottom of the pile, and just stick to what you're familiar with. Take the time to really go, you know what, I don't know much about JR, I'm going to have to focus on that a bit more. And just in terms of it's not like deviling where that's your job for 9 months, you're all still doing a day job. I would simply say just be clear to your colleagues about the time that you need and the commitment that it requires. I would say treat them like days of annual leave. I'm not saying take annual leave for them, speak to your employers about them, but treat it like annual leave. You're not doing client work, you're not available to chat about cases. It's a study day for you, and be disciplined about it. And it's all just about communication with your colleagues and those that you're working with. So that would be my sort of thoughts on the exams and what I can remember from the run up to them.
Thanks, David. Patricia, I'll pass over to you.
Thank you, Chiara. So kind of just building upon David's last tip there, I was wondering if the panel have any other sort of practical considerations or tips for our audience to take on board, obviously in addition to the very helpful tips that we've already discussed, and outside of the course itself. So for example, funding, balancing other commitments, support amongst other people taking the course, that sort of thing. So I'll come to Ian first, if that's okay.
Yes, of course, Patricia. Yeah, well, that's, I suppose, the two obvious aspects is the cost of the course itself, and how you balance doing the course and the time commitments with your day job, basically. So I think on that first point, I think most firms now would stump up for the cost of training, and I think, like our firms, normally there'd be some sort of clawback arrangement whereby if you do the course then and it's paid for by the firm, if you then leave the firm within a short period of time, you might have to pay that that amount back. So but I think most firms will pay for that course, and I think unlike I think of all the qualifications one can do, and I think I would always encourage any young lawyer to keep doing qualifications throughout their career, but of all of the ones that you can do, this one seems to be the most, I would have thought, the most obviously justifiable one for any litigation lawyer. And we can maybe come on to the benefits a bit later, but there's just a whole load of benefits even outside. Sorry, a bit of interference there. I think there's a whole load of benefits even outside the sort of business aspects, but we can come back to that. So that's why I think most firms, I think, would probably agree to fund the course for you. But obviously that's something that you should discuss with your line manager before you embark on and certainly apply for the course. As to the time commitments and balancing those with your day jobs, I mean, I would like to think that I don't remember getting really any dispensation when I did it, but I think now probably line managers manage these things much better, and I would agree with David. It's all about communication. So speak to your line manager if you want to do the course, ask about funding, get that sorted, and then also talk about support and time off to do the course. And obviously, to have that conversation, you'll need to be clear and communicate with your line manager what the time commitment is. But be clear with them. Then I'm sure any good line manager will be content with that and will be able to make the necessary arrangements. I mean, there's no doubt, even with that support, it's an extra burden. Anyone who does an extra qualification along with their day job, it's extra work, it's hard work. You've got to be committed. You can't do it half-heartedly, but I guess it's like anything in life, anything that's worth doing at all is worth doing well and putting the effort in. So you just have to accept that and get on with it. And I think anyone with an interest in this area will enjoy the course. Obviously, there's aspects of it that you wouldn't automatically want to sign up to, like the doing of exams, but they're clearly a necessary part of the course. And I think you will, as we probably all said in the panel now, you'll probably find that you enjoy those aspects a lot more than you expect to.
Thank you so much, Ian. That's really helpful. Lauren, do you have anything to add on the sort of practical balancing other commitments side of things?
I think really just, echoing exactly what Ian has said, and David as well. And I was in a really kind of fortunate position. I had a very supportive partner who I was working for, but I had very supportive colleagues as well who what David was saying, were able to, you know, keep some work away from me essentially, just whilst I, you know, was undertaking the, you know, the studying. It was 10 years since I'd been at university, so it was actually, I think for me, it was more about getting myself back into a mindset of studying again, and, you know, finding a way that, you know, that worked for me, in a way that I could, you know, that I could digest. And I was just trying to be quite disciplined. I don't know if it was the same for David most recently, but as I remember, the procedure exam and the ethics exam, there was quite a long lead into that for me. So I finished the course in February, and I don't think my exam was until April or May. So actually there was quite a long kind of lead in terms of studying, and it was just about being, you know, quite disciplined with it, and setting aside, you know, some time to, you know, to do that. And as I say, and as Ian was saying, I had a little bit of kind of study leave, you know, as well, with the support of, you know, of colleagues. So, but I would really just echo everything that Ian has said. Speak to your line manager, you know, about it.
Thank you, Lauren. David, I know you gave some tips on this point before, but anything to add?
I think it's been alluded to, but one point I would not underestimate is you don't do this course on your own. I think there were 7 or 8 colleagues from across the profession who I was doing the course with at the same time, and you build up a really good rapport with them. They become very good pals for the duration of the course, because they're going through exactly what you're going through. And to me, that was a really helpful outlet for stresses or concerns or queries, just to say, oh, have you got this? Do you understand this document, or do you understand this aspect of the training, or what's expected for that? And that was really good just throughout the whole thing. And even now, when I see the people from the course, there's that sort of shared bond of having been through it all together. And particularly on, for example, your the day you're doing your oral submissions in the court session, you do it one after the other, so you're sort of seeing each other about Parliament Hall, and there's that nervous excitement, and you're all there to support each other and help each other through the course. So would really recommend doing what you can to, if you get onto the course, to really invest the time in that relationship, because it's something that's going to help you as you're going through the various exams and assessments that are required. And also, I do talk to other solicitor advocates. There's a society, it's the Society of Solicitor Advocates, which every SOLAD's entitled to join. You get your first year free after you get admitted. They've got their website. So if you don't have any SOLADs at your firm, or you don't have a good relationship, absolutely get in touch, because there's a lot of support out there, and certainly I would, and I can think of lots of other solicitor advocates who would never hesitate to spend some time explaining the course, or trying to help someone who's maybe not quite sure what's going on with it.
Thank you, David. That's really helpful, and I can attest to that myself, and I'm sure Chiara can as well. The benefit of having a running mate, having just sat my SQE exam, and doing so with a friend and a colleague. So it's really nice to hear that there's that camaraderie for the SOLAD course as well. I will pass back to Chiara now for the next question.
Thanks, Pat. Sorry, could not find my mouse there. Okay, so I think that the next question was about your day job. So obviously this is something that runs alongside. You've all touched on the fact that, you know, you're doing this exam while you're still doing the day job. But how has becoming a solicitor advocate actually changed your day job? You know, after having completed the exam, you're now a solicitor advocate. How is your job different now compared to what it was before? I will come to Lauren first for this question.
Thanks, Chiara. I think for me, it's just maybe about having kind of 2 sides to my practice. So, or 2 hats, you know, so on the one hand, I have my instructing solicitor, you know, role, and which I really enjoy. I really enjoy the variety of what I do, which is partly why being a solicitor advocate was such a big kind of motivator for me. So on the one hand, I have my instructing solicitor hat on, you know, where I'm instructing counsel, I'm in the Court of Session, and then on the other hand, you know, I am the solicitor advocate, and I am, you know, I'm the one doing the appearances in the court of session, or I'm drafting opinions, or you know, drafting pleadings with that hat on. So I think for me, it's about the, you know, the variety, and just being able to kind of switch between, because I enjoy them both. I enjoy that dichotomy of, you know, on the one hand being the instructing solicitor at times, and also you know, being the solicitor advocate. Another thing for me, and so I do quite a bit in the way of, you know, whether it's opinions or drafting or appearances. For the firm, I think there is the benefit of having a solicitor advocate that, you know, inevitably when, if something urgent comes in, you know, you're on hand, that you can go up and you know, and deal with it. And there's the obvious kind of business case as well, that you know, and to be crude about it, that those can, you know, those fees are better retained to the, you know, your firm, rather than, you know, as disbursements to the faculty of advocates. So if it's something I'm able to, you know, to do, I'm genuinely enthusiastic to do it. By the same token, if it's something that's not in my wheelhouse, I'm quite quick to, you know, I would be quick to say that, in terms of if somebody came to me, and no offense if there's any family lawyers on the call, but if somebody came to me and said, you know, here's a divorce petition, do you want to go and do it? My answer would be no, you know, because it's just not my area of expertise at all. So the other side of my practice, I think that from, you know, becoming a solicitor advocate is, I'm really enthusiastic about bringing on and training other, you know, solicitors, and bringing on other potential solicitor advocates, you know, and doing that from the kind of grassroots. And, you know, whether that is hosting workshops about kind of written pleadings, or, you know, mock, you know, hearings or things like that. You know, for me, a big part of my practice is trying to bring on other people through the grassroots, and trying to inspire and encourage more solicitor advocates to come on board.
Thanks, Lauren. Ian, I'll come to you next.
Well, thinking back, I mean, when I first qualified as a solicitor advocate, I think at that time, our firm was certainly, my job, we were dealing with higher value cases than I had before, and more complex cases, as you tend to do as you get more experience in your career. So a lot of those cases were in the Court of Session, as opposed to the Sheriff Court. And in you know, back then, there was a large volume of the caseload in the Court of Session, whereas, you know, quite a bit of that work has been pushed back down to the Sheriff Court more recently. So I suppose the immediate change was, in my day job, I was able to do those Court of Session hearings and, you know, maintain an ability to actually appear in court, because I think the opportunities were diminishing at that time. So I think that was a great thing, because that was something I really enjoyed. So in terms of changing my day job, I suppose gave me that opportunity. I mean, I did proofs in the Court of Session, and I hadn't actually done that many Sheriff Court proofs prior to that. It'd mainly been debates. So I guess I did more proofs than I did them in the Court of Session. I did an appeal quite early on as well in the Court of Session, which obviously I wouldn't have had the opportunity to do. And I think the other part of the day job that changed was doing a lot more pleadings work, you know, Court of Session pleadings work, which is something I enjoy, and, you know, doing notes of argument and procedural notes for the commercial court and that type of thing, which before you'd always have deferred to counsel on. So, you know, like Lauren, there are obviously still cases where it's appropriate to go to counsel, but at that time, you know, it was a great opportunity to do more of that stuff myself. I mean, I think one thing I would say though is that now I think as you get on in your career as a disputes lawyer and a partner in any firm, it does become increasingly difficult. I think the bigger the team you start to run, the more you get involved in management, it becomes increasingly difficult to be able to devote the time to do solicitor advocacy properly, particularly hearings of any length, including the prep time and so on. So actually the ideal time to start thinking about being a solicitor advocate is early on, and then taking that opportunity, because I think if you leave it too late, it does become increasingly difficult. And I found myself that really in the last few years, it has been really challenging doing solicitor advocacy and in terms of appearance work rather than pleadings work. And I think probably, you know, my days of being able to do that are a little bit numbered, which is a bit of a shame. But you know, that's just the way careers develop and change. So I think that's something to bear in mind for everyone.
Thanks, Ian. And David, anything to add to that?
Really just to supplement what's already been said. Lauren mentioned wearing two hats. It's definitely an extra layer to your practice, in that you find yourself with court deadlines, client deadlines, colleague deadlines in a slightly different way. And certainly I had a really good conversation with a colleague where he was after something for the deadline that he wanted it for, but it wasn't a court deadline. I said, look, I'm really sorry, but I've got a stack of written work to get through by these deadlines, so I'm just not going to be able to do that. He said, oh, that's no problem at all, and rejigged when he needed me to come back to him. And it's really just about being open and making sure that you do have those conversations, because the great thing about this solicitor advocacy qualification is it adds another string to the bow of whatever team you're in at your firm. It gives them a capability that they didn't have before, and it's there to be used, it's there to be utilized. But that also means that you have to be given the time to do it and to do it properly, because you can't, rushing out a set of pleadings is never going to end well for anybody. They need the time to be carefully considered, they need the time to be carefully framed. So that's definitely a challenge of it. One of the things I like about it is a wee bit extra variety for me in the job that I do, in that as a solicitor, I tend to solely do work within the real estate litigation team at Brodie's. As a solicitor advocate, I get instructed by our contentious construction team, our professional indemnity team, our wider commercial litigation team. So you can begin to work with different teams, bearing in mind, of course, the caveat that Lauren quite rightly flagged of sometimes things start to get a little bit out of your comfort zone. And I adopt a very similar approach whenever the family team at Brodie's might come towards me with a query. We've thankfully got Susie Mountain up in our Aberdeen office who has the higher rights of audience and can handle all of those particularly tricky ones. The other thing as well, and this is about having faith in your own judgment and your own ability, is that if you're instructed as a solicitor advocate, you have got a slightly different role in the case. You will be that bit more detached from the client. You will be expected and be instructed to give a more independent view, which can sometimes mean saying to a colleague, it might even be a senior colleague, quite often is, I don't agree, my analysis is this, my opinion is this argument will fail. My opinion is we need to revise prospects down. And those can be really difficult conversations to have when you're dealing with senior colleagues or even someone who might have trained you and developed you. But that's part of the role. And that all comes down just to backing yourself. And in a brief final rebuttal just to Ian's point about management getting on top and maybe stopping an aspiring solicitor advocate getting where they want to be, I would simply play my Christine O'Neill KC card and reply. And Christine, I'm very lucky at Brodie's to have Christine as a colleague. She's a formidable solicitor advocate, is also chairman of the firm, and does a tremendous job of balancing all of those commitments. So don't think it's an either or. Ian's definitely right to flag that it can be a difficult path to tread, but it's not an impossible one. So for anyone is thinking about being a solicitor advocate but also has ambitions to get to the top of their law firm, it's absolutely something that can be done.
Yeah, can I just follow on that? Because sorry, if I gave the impression that it's a bit of a conflicting position, I didn't mean to. What I meant to say was really over my timeline in recent years, but bearing in mind I qualified in 1995, so it hasn't really been a problem throughout all of that time. But you know, there's no doubt, you do get to a stage where there are more and more things that, you know, you take on, and it does get more difficult to balance things. But really, I was only making the point in that respect to say that actually, if it's something you're thinking you would like to do, then the sooner you do it, the better. And you know, you'll be able to, if you qualify, you'll be able to do it for many, many years then before you get, you know, the sort of tensions that I'm talking about. So I'm talking about quite a recent thing, but.
Yeah, thanks, Ian. I think maybe it is something that more junior members of the profession think, oh, that's something that you do when you're more experienced type thing. It's not something for me right now. So thank you for that. Okay, well, I think I'll pass back to Patricia for a final question from us, and we'll just encourage if anyone has any questions, and feel free to pop them in the chat. But I'll pass back to Patricia for our final question.
Thank you, Chiara. So I actually prepared this question before this evening's proceedings began and before I knew what the speakers were going to say. And not at all that I thought it was going to be, you know, a negative report on being a solicitor advocate, but I almost feel like I don't need to ask this question because it's been so overwhelmingly positive, but I'm going to ask it anyway. So can I ask you to reflect on the sort of primary benefit, to sum us up, leave us on a high, primary benefit of what you found from undertaking your additional qualification, becoming a solicitor advocate? I will come to David first.
So a one-liner summation. I think it's just part of being a member of a really interesting group of lawyers who I think, as hopefully has been clear from this panel, all really enjoy being in court, getting into the books, getting into the thick of the argument, getting into the thick of the evidence, and really just very often taking an area of law that they practice in and just wanting to get to the next level in terms of their ability to argue and win cases for their clients. And I think that the solicitor advocate qualification is just such a brilliant founding step for anyone who wants to aspire to that in their career.
Thank you, David. You've almost all sold it to me. Almost. Not quite. I'm not ready for another additional qualification just yet. Lauren, if I can come to you next.
Again, just exactly what David has said. It's just something I'm so enthusiastic about. And Patricia, you know very well how much I like to geek out over kind of procedure or law, or, you know, and I think I'm maybe a better solicitor advocate than I am an instructing solicitor at times, because often in the court of session I would have to sit on my hands because I wanted to be doing it myself. You know, I wanted to be the one that was up there, you know, just because I'm so kind of passionate about it, and I love a rule and I love a procedure, as you know. But I think the takeaway point for me is that, you know, the course is accessible to anybody that wants to do it. It is designed for people to, you know, to pass it, and it's just, you know, I think anybody considering it, it's worthwhile, because I felt I learned so much, you know, just even about pleadings in the sheriff court, or even about, you know, if I didn't have my solicitor advocate hat on at all, you know, I just felt that I learned so much through the process. So I would absolutely encourage anybody to that was thinking about it, just to do it. And my one takeaway tip is that as part of the application, as David said, you have to go back and kind of set out your experience. Try and keep, if you're thinking about becoming a solicitor advocate just now, try and keep a record of the cases that you've done, or the substantive hearings, or the, you know, the interim interdicts or things like that, because actually to try and go back 5 years and remember is quite difficult. So if you have a wee kind of folder or a note of the cases that you've been involved in, then that makes that process much easier.
Thank you so much, Lauren. And last but not least, Ian.
Yeah, I think the solicitor advocate qualification in the course, I mean, it brings you on in so many ways. It develops you and trains you in so many different ways. I think, first of all, it's a fantastic training course. So even if you came out of it and never did any solicitor advocacy, you'd have learned an awful lot, as Lauren has said, about pleadings, and really the whole point of the court process, pleadings process and advocacy. But I think, secondly, and I suppose you don't need to be a solicitor advocate, obviously, to do plenty of hearings and so on, but I think when you're a solicitor advocate, you get involved in some complex cases and difficult hearings. And I think there's a number of consequences I think it has for the way you work and the way you look at cases. And there's three things I would say. I mean, first of all, you've got to remember that what you learn in the course by way of presentation and pleadings and so on, it's not just applicable to your next appearance in the Court of Session or Sheriff Court. It could be arbitration, it could be adjudication for construction disputes people, it could be a presentation and mediation. You know, they're very transferable skills that you learn. And I think the second thing is I've found that the act of being up on your feet and arguing your own pleadings, generally with somebody on the bench who's a lot cleverer than you, it makes you become much more ruthless in your arguments. So whereas before you might have pursued some slightly dodgy arguments before the sheriff in the hope that something would land, you tend to be much more ruthless and focus in on what the good arguments are and really, you know, work on those. And I think the third thing is it makes you much better at articulating your sort of inner thoughts, because you have to stand up and tell somebody, again, who's generally speaking much brighter than you have to tell that judge, what is your case? Why have you pled it in a particular way? Where is it going? And of course, that person often either won't agree with you or will probe. And that was a big difference I found going from the Sheriff Court to the Court of Session, is that in fact, I remember my first hearing in the Court of Session, I barely started. I barely got my first sentence out when the judge said, Mr. Drummond, your case is all about this. Well, what about that? And he homed in on the biggest weakness in my entire argument. I thought, my goodness, you know, I barely started. And it's those experiences that they just make you prepare, and it's lessons that stay with you in everything you do, because from then on, every time you prepare a bit of written work or every time you prepare for a hearing, you're always thinking about, well, what if I'm asked about that? Or why am I writing that? What if I then have to explain that to somebody? You know, it gives you that extra discipline. And I've always found that in whatever I do, actually, even down to writing letters and so on, it just gives you that extra edge and that extra layer of sort of requirement to analyze and think things through properly before you proceed with them. So I think it's the best training you can get as a disputes lawyer.
Thank you so much. As I say, an overwhelmingly positive report on being a solicitor advocate. We have one question in the chat box so far. We'd encourage the rest of our audience to post any queries or questions. So it says, do you have to be dual qualified to become a solicitor advocate? I believe the answer to that is no, but I'll let the solicitor advocates confirm, but I think the answer to that is no, and it's maybe me confusing things earlier on.
No, you don't need
to
be.
No, so that's good. Tick. Any other questions? Also, if anyone wants to pop their video on and ask a question with the mic on, that's totally fine.
I'll take that as we have done so well with our questions that we have chosen that no one feels
so thorough.
More.
I actually just had one quick question. Sorry to be that guy at the end of the event who's like, I have one question. What happens if it doesn't go so well on the day and you are required to resit? No one knows because everyone passed first time.
No, it's actually I think it's very similar to university exams, in that there are resit diets. There was someone who had failed the judicial review element of the course, and what they were able to do was come back the following year to try and complete that element of the course, which they did, and they went on to be admitted with the higher rights of audience. So the Law Society is good at counting for that. But so yeah, there are resits available, and same for the oral examination as well. That you can be given another go if it, as you say, if it doesn't quite go to plan on the day itself.
Thank you, David.
Yeah, you've reminded me, David, because funny, my wife was saying this to me, was reminding me of this the other day, that I actually sat one of my exams at the reset diet, and she reminded me that it was because she gave birth like at the time when I was due to be sitting the actual exam, and she reminded me that I was very worried that going along to the reset diet, everyone would think I'd failed that exam. I was actually doing it. But yeah, there's resets, and I remember it being fairly relaxed. You know, I don't remember anyone standing at the door giving us the evil eye as you went in, you know, thinking here's a whole load of people that have failed. So
yeah,
that's good.
And the Law Society can be quite flexible with the dates. I know this year I did my professional conduct and my practice and procedure exam on the same day. So I did professional conduct in the morning, practice and procedure in the afternoon. That wasn't possible for some of the candidates. So I think it was the professional conduct they delayed. We had to give an undertaking that we would not discuss, mention, or disclose anything that had come up in the professional conduct exam until a few days later when they'd had a chance to sit it, because the Law Society, as I said earlier, does appreciate that we're all busy professionals. We have our practices as well. We have other things going on in our lives. So they're generally pretty good about trying to arrange things to suit people as best they can.
Thank you. That's really helpful to hear that flexibility is there, because as you say, everyone has busy schedules and different schedules. There's one last question come through on the chat from Alex. So thank you, Alec, for posting that. Alex has asked, what would your top tips be for someone considering the course in terms of getting as much of the relevant experience you need before applying?
I would definitely recommend like speaking to your colleagues, because the way I was able to do it was because I had so many people kind of feeding me opportunities, you know, to go and do the proof, or you know, the debate, or to draft pleadings, or you know. So I think, one, it's about being, you know, showing that you're keen, you know, to do that. And I think maybe discussing your aspirations with your, you know, with your colleagues, and you know, as I say, my own experience was that most of that substantive work was diverted to me, to, you know, to be able to do. So you know, I'm sure most people's colleagues would want to, you know, to support them, to, you know, to meet the criteria, if that's what your aspiration is, to become a solicitor advocate.
yeah, and I was just going to add something to that, that we've always, you know, because we've got a number of solicitor advocates in the firm now, and I remember, you know, the last few who've done it did exactly that, as Lauren said, and you know, looked for appearance work and so on. And there was all they were always worried about, but we'd normally perhaps give this work to a local agent if it was, you know, the sheriff court in Inverness or whatever. You know, what are we going to do about all the travel time and so on? And it was a, you know, a managerial decision. Well, that's fine. You need this experience. We'll write that off, and you know, that's all part of your training and development. So I wouldn't be sitting there worrying about that. I'm sure your line managers will be quite flexible about those sorts of aspects.
Yeah, I'd just add as well that there may be opportunities in your firm for you to deliver training, or for you to go to external events and then report back. I mean, so for example, in the business dispute team at Brodie's, we have a forum every 6 weeks or so where we all come together over a lunch hour, and normally 2 or 3 people will speak about recent cases or recent things they've been at. Get out there, do that, go to the training, or offer to say, oh, I've just had a really interesting opposed motion on a specification of documents. Shall I do half an hour on what are the tests for recovering documents? When will recovery be granted? When will it not? And that just gets you out there as someone who's interested, and also as someone who's demonstrating to your colleagues that you know what you're talking about, you know how to deal with these issues. Because the reality of appearing in court, you're at the sharp end of it. You don't really have anywhere where to hide. Judges don't generally react too well if you say, "Oh, can I have 5 minutes to go and look that up?" if it's a point that you should really have considered before the hearing. So in terms of getting your colleagues to engage with you, that can be a really good way to show that you're available for instruction, and that you'll be able to do it. So using my commission and diligence example, if you do some training on that to your colleagues, the next time one of them's got an opposed motion, they might go, I know David did training on that a couple of months ago. I'll go and see if he wants to go and do the hearing. And that can just be a really good way of not just saying and trying to get work, but showing that you're in a position to take it on for your colleagues.
Thank you so much, David. And thank you very much to all of our panelists this evening. Lauren, David, Ian, genuinely thank you so much for joining us and giving us an insight into life as a solicitor advocate. I'm sure that many of the members on the call have taken a lot away from it, and you might have even just encouraged Patricia and I to go and do it as well. But thank you to our members as well for your engagement with the event. And just before we log off and let you enjoy the rest of your evening, we want to flag that our annual Women in Law seminar is taking place online next week on the 16th of March. The theme of this year's event is Global Rights and Autonomy, and we have secured a fantastic panel to speak to this topic. Tickets are £5, but the cost of your ticket will be donated to the Women's Refugee Commission. So if you are available next week, then please do sign up, and we'll see you there. Thank you very much.
Thanks, Patricia. Thanks, Chiara.
Thank you.
Thank you, everyone.
Thank you.
Thanks very much. Bye-bye.
Bye.